Can you introduce yourself for our listeners?
Hi, I'm Angela Hallier of Hallier Stearns Law Firm. I am a family law attorney.
Angie, have you done any work in the domestic violence field?
Yes, I have been practicing for 31 years, and being a domestic violence survivor myself, I was interested, even as a young attorney, in providing free legal services to people in shelter to assist them navigating the court system when it comes to family law and divorce.
What would you say you've seen as a survivor's biggest obstacle in approaching family court?
The continued fear and not feeling safe. So the family law courts can help you if they believe and they know about the dynamics and the situation of domestic violence. But often I find that even after people have left their violent partners, they're still worried about what that person can do to them, the repercussions. Will they and their children be safe? And it is a legitimate concern if you don't have the right advocate for you in court, because abusers try to continue to abuse through the court system. So it's really important to have the right advocate who will make sure that doesn't continue and who can educate the judges about the situation and the domestic violence in this particular case, because judges are receptive to acting when they know about domestic violence occurring, but sometimes they have to be educated because most of them haven't gone through it themselves. And the training they receive on the issue of domestic violence is really kind of a pared down, glossed over picture at that issue.
Now, when you're going through your forms, there's that checkbox that you can tell the court whether or not domestic violence has occurred. The court notes that it's significant domestic violence. What does the court see as significant?
Right. So that is a tough issue sometimes because the level of domestic violence that occurred can impact legal decision making, parenting time, all the aspects of custody related issues. It has been my experience that most judges need more than just your recitation of what occurred. They need a doctor visit that you had, a hospital visit that you had, that the police were called, or that you had neighbors that observed it, or family members that observed it, or there were injuries otherwise documented. If you just tell the judge that your spouse threw something at your head multiple times or pushed you against the wall, it's difficult for the court to find significant domestic violence occurred. But I have found that other witnesses, even if you don't have a document or an injury, if there have been other witnesses that have seen it, calling those individuals as witnesses is very helpful.
And when I was going through my divorce and things got pretty heated with Alex, I think you'll recall that there was a night that he came into the room when my daughter was there, and I wasn't really sure how that would play out. And I didn't plead to significant domestic violence or any domestic violence. I didn't get an order of protection or exclude him from the home. How do you think that choice impacted my case long term?
Well, I think that you have, if I can speak freely, I think that
Absolutely.
your case has evolved to probably where it might have been earlier had you focused more on the domestic violence earlier. However, there was a very significant concern in your case about your ex-husband continuing in his job with an order of protection against him. And that's a very real concern that has to be weighed, because if he had lost his income, you would be potentially in a very negative place financially. I think probably in the end, it was the right decision if he was going to face the potential of losing his job. But I think it certainly cost significantly more money because the unraveling of his personality took longer. It required you to go back to court. I mean, on the other hand, even if you would have done that, there was just you to say what he did. And he might have filed and fought it. And then it would look like, that's always the catch 22, is that if all you have is your word, no text, no communications, no pictures, sometimes that's not enough to maintain the order of protection, even after you get it. And the other thing that order of protection does, and as I recall, we talked about this, is, I mean, it makes the person very angry, even more angry than that angry person already was. So I think it's also a call on the level of violence. Had you been in the hospital from injuries, there's no question that we would have done that.
Now, for a lot of survivors, what if the only witnesses are your minor children? What do you recommend in that circumstance?
Yeah. If there is a therapist available, have the children tell their story to the therapist who can then testify about what the children have said, because people who work in that arena will not only be able to testify about what a child has revealed to them, but whether, in their professional opinion, they find the child credible, which is important, right? Because even though there's a statute that allows judges to actually interview the children, they never do that. They don't want to do that. The court does have the ability to appoint family court advisors that at a very low cost or no cost whatsoever can talk to the children and interview them and get their feelings. But children can be truly legitimate and valid witnesses as to that. So, as to some extent, you don't want to involve your children, but if the child is just telling it to someone who's trusted, who can then report it, that has weight.
And if I'm going for an order of protection, so I've had an incident with a significant other and my children witnessed it, can I name my children on that order of protection if they were not directly the target of the threat?
It depends. It depends if they just witnessed it from afar or were they in the middle of it? Because in Arizona, intimidation, threats, that kind of thing that you can't see or touch is still a part of our domestic violence definitions. So while the child may not have been the exact victim of the domestic violence, there's often ways to weave that in to say that they felt intimidated, because if a person feels intimidated, that's a form of domestic violence, or were harassed. It is, at least the way our court system is today, you often need more than just the child was there. You have to describe in your petition for your order of protection that the child fell to the ground, that the child ran away, that the child tried to attack the abuser, something more than just observed. But it is possible, if they were there, even if they weren't the target initially of the domestic violence.
Now, if I can't afford an attorney and I have to go to court, what's your recommendation? What are things that I should make sure I don't overlook?
Okay, so I mean, there are some no cost advocacy groups that can assist you and go to court with you. So just know that and look for that. It's important just to stay very calm and write out ahead of time what your story is. In getting an order of protection, if we're talking about that, if we're talking about obtaining an order of protection on your own, be very specific when you fill out the form as to dates things occurred and what specifically occurred. You need to show the judge that there was actual harm, whether that was emotional harm, whether that was physical harm. So it has to be more than he burst in my house. It needs to be he burst into my house unexpected, shook his fist at me, threw me against the wall, whatever is very specific about that event. Because if that is challenged, if the order of protection you've obtained is challenged, you can only rely on what you said in your petition. So take as much time as you need to be very, very detailed about all the incidents that warrant you getting an order of protection.
For family court, how do I approach it if I'm going in on my own and, dad's saying I'm crazy and I'm really just scared and I want to protect my kids?
Right. So, not knowing the specific situation, but you can tell the court you're very scared, because the rules of evidence at court in Arizona are very relaxed when it comes to representing yourself. You are not required to be formal like an attorney with exhibits or asking questions and answering. Most judges just let you tell your story. So again, write it down before you go so you can tell the judge, this is what happened. This is what I think is best for the children. This is what he did, and admit to the judge that you're very scared. You can even ask to leave if you're exiting the courtroom and you were afraid that your abuser will come after you in the parking lot or outside the courthouse, you can even ask the judge to allow you to leave early and have the other party stay in the courtroom for 5 or 10 minutes until you're gone, if that's your fear, or to have a sheriff escort. They will give you that too.
Is that something I can call ahead and ask for?
That I don't know, but you would call the judge's chambers. So there's a clerk at with every judge, and you could call the judge's chambers and let them know that you are concerned and can you have an escort bringing you up or bringing you down.
I think that's great advice. Is there anything else you'd like people to know
About
about approaching family court if
oh,
if domestic violence is at play?
yeah, I mean, you do have to be careful going in and going out, and the courts are aware of that. I just think, maybe bring someone with you. Anyone can go to the courtroom, and often you feel better if you bring a friend or a parent or a sibling with you to the courtroom just to be there, just to observe, just to sit in the back, no interaction, but someone that can give you moral support. You can bring anyone you want.
I think that's a really good piece of advice too, because when you're in the moment, it's so much information and it feels like people are speaking a different language. Having a second set of ears is sometimes helpful to process afterwards too.
Mhm. I agree.
Well, I appreciate your sharing your time with us today.
Thank you. Thank you so much.